The time right now is 12:45 p.m. I'm Dr. Felix Yip, Chair of the committee. I would like to ask all of us to please turn our cell phones to silent, and for the board members, please make sure they're off the table so we can avoid feedback noises. You may notice board members access the laptop during the meeting. They are using the laptop solely to access the board meeting materials that are in electronic format. This is an official business meeting of the Medical Board of California. As such, disruption of the board's business will not be tolerated. We have Kara on my side to enforce that. We have a designated time on the agenda for public comment, and we will be asking for public comment on each agenda items. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forgot to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you'll be recognized. I would like to request all speakers to complete a presenter slip so I can call you by name at the appropriate time, and the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slip to Ms. Chu. Ms. Chu is right here. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via the teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star 1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, press the pound sign. Please remember to mute the volume on your screen to avoid feedback noises. Assistance available through the teleconference meeting. To request a specialist, press star 0. Each person will be limited to 3 minutes per agenda item. However, during agenda item 2, public comments on items not agenda, the board has limited the public comment period for individuals on the telephone conference and those present here today to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda items, 10 minutes will be allowed to comments from the individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Staff from the board's business service office will be assisting me with receiving the public comments via telephone conference during this meeting. I would like to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. I would like to call this meeting to order and have Ms. Chu please call the roll.
Dr. Bolot?
Here.
Dr. Kraus?
Present.
Ms. Yaroslavsky?
Present.
And Dr. Yip.
Present. Thank you. A quorum is present. I would like to remind the members that we will be taking a roll call vote on all action items. Let's move to item number 3, public comments on items not on agenda. I do not see any speaker slips for the items not on agenda. Are there any comments on the phone? If yes, please limit your comments to 3 minutes.
Comments on the phone?
No? Okay. Well, let's move on to our next
No
agenda.
comment.
Thank you. Fine.
Is one?
No.
No? Okay. So let's move on to item number 3, approval of minutes from October 29, 2015 meeting.
So moved.
Are there any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the phone?
No, there are no comments.
Thank you. Ms. Tu, please take the call.
Dr. Bolot?
Here.
Dr. Kraus?
Yes.
Thank you. Ms. Yaroslavsky?
Yes.
And Dr. Yip.
Yes. So minutes approved. We now move to agenda item number 4. Ms. Delp, please provide an enforcement program update.
Thank you, Dr. Yip, and good afternoon, board members. The expert reviewer training is scheduled to take place on Saturday, March 19, 2016 at the UC San Diego School of Medicine. The full day of training will include welcome remarks from Executive Director Kim Kirchmeier and Enforcement Committee Chair Dr. Felix Yip. Also on the agenda will be an overview of the expert program's mission and expectations, legal considerations when opining on a case, a rundown of different case scenarios, and segments on testifying provided by the perspective of a retired administrative law judge, a deputy attorney general, and a defense counsel. The training will end with a review of a mock case, and attendees will be asked to provide a written opinion regarding whether the physician departed from the standard practice of medicine. Board staff will review the opinions, and feedback will be provided to the attendees. Last Friday, a save-the-date announcement regarding the training was emailed and mailed to experts in the San Diego area and surrounding territories, and already the board has received interest to attend from several physicians. A formal invitation to attend the training will be sent out within the next couple of weeks, and additionally, staff is looking into the possibility of conducting a second training this summer in Southern California and training this fall in Northern California. Training with the Office of Administrative Hearings will begin this month. On January 29th, the administrative law judges will receive training on anatomy and systems of the body. Lining up additional trainers has been challenging. Conflicts arise when the days the instructors are available are not in sync with the days the Office of Administrative Hearings has set aside for the training. Nonetheless, the board's efforts will continue, and I may reach out to board members to assist me in identifying a speaker to provide some of the training. On January 5, 2015, Enforcement Committee Chair Dr. Yip spent the entire day with management and staff from the Northern Probation Office discussing how the probation unit operates. Dr. Yip reviewed the daily functions performed by staff and the methods used to monitor a licensee's compliance with the terms and conditions of his or her probation. The meeting was very productive, and some new policies and procedures to streamline and improve the probation monitoring process will be implemented. Later on in the Enforcement Committee meeting, I will provide a presentation to the committee members about the probation unit's roles and functions. At the October board meeting, I mentioned an issue raised by the Office of the Attorney General regarding the use of the same investigator that works a complaint both criminally and administratively. On December 8, 2015, Executive Director Kim Kirchmeier, Ms. Webb, the board staff counsel, and I met with executive and legal staff from the Department of Consumer Affairs, staff from the department's Health Quality Investigation Unit, and staff from the Office of the Attorney General to explore this issue. The discussions were enlightening to all that attended, and the meeting adjourned with an agreement that staffs from the Attorney General's Office and the Health Quality Investigation Unit would resume discussions at a later date with hopes of drafting a policy to be considered by the Department of Consumer Affairs. On a separate note, the board took measures to mitigate a concern raised by the Attorney General's Office that complaints being investigated for criminal prosecution are not being tracked effectively. As such, by not having a process to track the cases, the issue could adversely impact the board in being able to file timely administrative actions when a district attorney's office rejects the filing of a criminal case. To solve this concern, the board identified a staff person who is now actively monitoring the caseload. Lastly, Enforcement Program Manager Paulette Romero and Enforcement Unit Managers Charlene Smith, Ramona Carrasco, and Brian Curtis have been working diligently to evaluate the complaint handling process to find ways to improve the amount of time it takes to process a complaint. I commend their efforts and want to publicly thank them for developing a plan to adjust caseloads and reorganize the Central Complaint Unit's reporting structure. By adjusting the caseloads, the complaints will be more evenly distributed among staff, thus decreasing overall complaint processing timeframes, and with reorganizing the reporting structure, managers will have fewer staff to supervise, affording each manager with more time to coach and mentor their staff to ensure they have the proper training and tools necessary to process complaints effectively. The proposal will be submitted to the Department of Consumer Affairs for approval, and once approved, the plan will be implemented. This concludes my enforcement update.
Thank you. Are there any questions, comments from the board members? Any public comments from those in the audience? Any comments from those on the phone?
Do we have comments on the phone?
No comments from the phones.
Great, thanks. Move to agenda item number 5. Ms. Robinson will now provide an update on the demographic study.
Good afternoon, Chair and members. At the last Enforcement Committee meeting in October, I provided information on the board's demographic study that is being conducted by the California Research Bureau. I'm happy to provide an update on the progress of the study. On December 20th, the Bureau met with interested parties that included Dr. Jackson and Dr. Savage, Minister and Co-Minister of Health for the Black American Political Association of California, and Dr. Lang, President of the Golden State Medical Association. This 2-hour meeting covered 10 items of concern, including the impetus behind the study. There may be additional information the Bureau needs to obtain from the board to review based upon this meeting, but that will be determined by the Bureau. Further, the Bureau confirmed that the report will be released to the public. Next, the Bureau will finalize the research design and methodology, then provide this information to Dr. Krause for review and approval, as approved by this board when requesting this report. The Bureau has anticipated that it will take approximately 2 months to finish the analysis, and an additional 2 months to finalize the report. I will continue to monitor the progress of this study and give updates accordingly. This concludes my update on the demographic study.
Thank you. Any questions, comments from the members? From the audience? Any comments from the phones?
Any comments from the phone?
No commenters from the phones.
Thanks. So move to agenda item 6. Ms. Robinson and Ms. Curry will now provide vertical enforcement report update.
As is required by law, the board has been working with the Department of Justice and the Department of Consumer Affairs to report and make recommendations to the legislature on the vertical enforcement model known as VE. VE initially began as a 2-year pilot program that was implemented in January 2006. The goal of VE is to bring investigators and deputy attorneys general together from the beginning of an investigation with the goal of increasing public protection by improving coordination and teamwork, increasing efficiency, and reducing investigation timeframes. Over the past 10 years, the board has provided 4 reports to the legislature on VE. The most recent report was included in the board's supplemental Sunset Review Report 2013, which is available on the board's website. In October, Ms. Anita Scurry and I began working on the most recent report due to the legislature by March 1st. The board's IT department has been working diligently to provide us with fiscal year 2013-14 and fiscal year 2014-15 statistical data needed to complete this report. The task has been a challenge due to the need to rewrite the report request for the language now contained in the new Breeze system. Once we receive the data, we will finalize the report and provide a draft copy to the Department of Justice, the Department of Consumer Affairs, Dr. Yip, and one other board member of Dr. Yip's choosing to review the report. We plan to bring the final report to the board in a special meeting by the end of February to meet our March deadline. This meeting may be held by teleconference. I will now turn it over to Ms. Scurry to discuss what she has been working on. Thank you.
For those of you who don't know me, my name is Anita Scurry. I was a supervising senior staff attorney with the Department of Consumer Affairs, and I provided representation to the board, the medical board, for 19 years in that capacity. And I also worked on the development of the new VE protocol after the board's investigators were moved from the medical board to the department. And I was asked to assist in preparing this report. We expect that our report will consist of 3 primary areas: the statistical data mentioned by Ms. Robinson, which we've been trying to get for a time, but it's trying to get apples and apples from 2 different data systems has not been easy. We also are going to talk about improvements that have taken place since the last report in 2013 and some recommendations for statutory changes. That's the primary focus. We have been working with the Office of the Attorney General as we have been preparing this report. Are there any questions?
Questions from the member? Any comments from the audience? Comments from those on the phones?
Do we have any comments on the phone?
Okay, great, thank you.
No comments.
We're looking forward to your report before the end of February. Okay. So moving on, agenda item number 7, investigation and vertical enforcement program report. Ms. Chris and Ms. Nichols will provide a program update from Health Quality Investigation Unit. And Ms. Castro will follow with program update from Health Quality Enforcement Section. And please.
Good afternoon. My name is David Chris. I am the new chief of the Division of Investigation for the department. Michael Gomez retired in December. I wanted to introduce myself today and tell you a little bit about my history. Previously to being selected as chief, I served as deputy chief of the division since 2012. I've also served in various investigative and managerial law enforcement positions in the past, including Deputy Inspector General Senior for the Office of the Inspector General, Supervising Investigator for the Investigation and Services Team, which is the Internal Affairs Unit for the department. And prior to working for the state of California, I worked as a police officer, a police corporal, and a police sergeant. What makes me truly unique is that I was also an investigator for the Medical Board of California in Los Angeles. And since the new year, I've been working with Kathleen Nichols to get up to date with things at HQIU. Currently, I plan to focus my efforts on filling our vacant positions, continuing the staff retention projects, the salary package, and field training officer pay, and continuing the strategic planning process, completing the combined DFI policy training manual, and developing a division-wide training plan. And then referencing our vacant positions, currently we have 26 vacant positions and 21 people in background for those positions, so we're making good progress there. And we have interviews scheduled to fill those remaining positions. And then additionally, we had some statistics and information that Kathleen is going to present.
Yes, at the last board meeting, a question came up about how we are prioritizing our cases for the board. So I just wanted to talk briefly about that. There's actually a Business and Profession Code section that mandates what the board's priorities are, and that information is in your packet. I won't read it verbatim, but to go over it briefly, it's section 2220.05. So the priorities are cases that involve gross negligence, incompetence, or repeated negligent acts that involve death or serious bodily injury to one or more patients. Cases that involve drug or alcohol abuse by a patient and surgeon involving death or serious bodily injury to a patient, repeated acts of clearly excessive prescribing or prescribing without a good faith exam. An additional one that was added per the statute as of January is repeated acts of clearly excessive recommending of cannabis to patients without a good faith exam, sexual misconduct, and practicing medicine while under the influence of drugs or alcohol. So what we have done is we have gone through our entire list of cases, identified which cases are priorities and which cases are lower priorities. Anything on this list has been deemed a lower priority case. Anything on this list is a priority. And how we're splitting our time is that we're spending 4 out of the 5 days a week, or 32 hours a week, working priority cases, 8 hours a week working lower priority cases, and then those cases will be rotated so that work will be completed on every case. But we're very focused on protecting the public and keeping the priority system that's already been established. And that concludes our report.
Any questions, comments from the board members? Any public comments from those in the audience? Any comments from those on the phones?
Do we have any comments on the phone?
Okay,
No
great.
comments.
No comments,
Can
great.
I just ask a point of information? Are we going to get regular reports back on your achieving those kinds of goals so that we will be able to monitor and know that, in fact, it's working? That you're...
Yes, and I believe there were some statistical graphs in your packet about cases over a year old and cases over 550 days old, and we will continue to produce those for you.
Okay, because we're starting to see more cases that were older than newer, or I'm starting to notice, and I'm
Correct.
just concerned.
I think some of that has to do with the vacancies, and also as you're prioritizing, if you're working, spending the bulk of your time as it should be on priority cases, some of those lower priority cases, we might see those numbers actually increase. But right now, this is all about, prioritization, protecting the public, and that's where we're at.
Okay, thank you.
It's one of those things that I work with the staff, hopefully provide like an aging report to report to the board. So.
Thank you.
Moving to agenda item number 8, Ms. Delp will provide a presentation on the probation unit's roles and functions. You change? Oh, Ms. Castro.
Actually,
Thank
I
you.
know I'm next, so that's why I'm up here.
Actually, you will be next.
Yes. And I'm going to have Mr. Bell sit here. Thank you. Good afternoon, Gloria Castro, Senior Assistant of Health Quality Enforcement Section. I come before you today to describe the status of the Vertical Enforcement Program, currently under the auspices of the Attorney General's Office and the DCA Division of Investigation Health Quality Investigation Unit. I've been the Attorney General's Health Quality Enforcement Section since 2004. I've been the Senior Assistant since April of 2012. I'm very familiar with the history of the VE program and with its implementation, especially since July 2014, when DCA assumed the investigative duties for medical board investigations. Additionally, a significant percentage of my senior HQE staff have 20-plus years experience in this section. They were here when the section was created in 1990. To my left, I have Supervising Deputy Attorney General Terry Jones, and in my back here, we have Supervising Deputy Attorney General Robert Bell. The goal of the Vertical Enforcement Program is to efficiently investigate allegations of unprofessional conduct, to close meritorious cases, and to prosecute worthy cases in a timely manner, in order, in the language of one court, to, quote, protect life, health, and welfare of the people at large, and to set up a plan whereby those who practice medicine will have the qualifications which will prevent, as far as possible, the evils which could result from ignorance or incompetency or lack of honesty and integrity. Two issues are adversely affecting the Vertical Enforcement Program. First is obviously the continuing issue of staffing investigative positions within HQIU. This problem existed before the transfer of investigators to HQIU and continues now to a higher degree. The turnover of investigators leads to the reassignment of investigations to new investigators who, despite undergoing training, are unfamiliar with the nuances of the Vertical Enforcement Program. And because of the unfilled vacancies, which at times have gone up to almost 30%, the remaining investigators strain valiantly yet unsuccessfully to keep up with their expanded caseloads. This adversely affects the ability of the Attorney General's Office and her cadre of experienced Deputy Attorney Generals to effectively direct investigations and the ability of HQIU to timely and expeditiously complete investigations, thereby drastically delaying public protection. In large measure, it is not until the administrative process is completed that public protection kicks in, and this is when we put the public on notice. And in the words of one court, that when we reach the administrative process, and that is with the filing of an accusation or the filing of an ISO, interim suspension order, that is when the public ends up finding out the unqualified and undesirable persons and those guilty of unprofessional conduct in the medical profession, which is a very small percentage, but very important to put the public on notice. So obviously the delays due to the lack of investigators means achieving the board's public protection mission is delayed. The second issue adversely affecting the Vertical Enforcement Program is the policy of HQIU handling administrative investigations as criminal investigations, and it takes those matters out of the Vertical Enforcement Program, which was established by the legislature as the best means to achieve protection of the public from unprofessional physicians and surgeons. Once a case is being investigated criminally, due process considerations prohibit the use of administrative investigative tools for the criminal investigation. And I know it's a very highly technical expression here that I'm trying to make, but there really truly is supposed to be a dual parallel proceeding. And as you heard from Ms. Nichols, we are working on it, and Ms. Delp also described where we are with that. However, the cases keep coming in, and we still have to move forward to protect the public. So, for now, cases within the board's central complaint unit are being referred to HQIU for administrative investigations under the VE program, under the direction of the Attorney General's office, but some are being diverted into criminal investigations by HQIU under the nominal direction of district attorneys' offices. Many, if not most of these cases, though worked up criminally, are not being accepted for criminal prosecution by district attorneys, and for valid reasons. These are very highly complex cases, and sometimes the expertise is not there. After a failed criminal investigation does not end up in a criminal filing, what ends up with happening to the case is that that case is presented to the Attorney General's office as a handoff case to be administratively prosecuted. And those cases, of which we had to come out of because they became criminal, have had none of the input required by the legislature when it created the vertical enforcement program. For these cases, and they're minimal for now, but that's why I'm bringing this to your attention at this juncture. For these cases, that handoff is actually a discredited method that was discredited 10 years ago when the VE program was created. The whole process, again, leads to delays in achieving public protection, usually on the most important cases. It wouldn't be classified as a criminal case if there were not very important considerations to it. And those are also ISO cases in many respects. Additional investigative efforts are sometimes necessary on these handoff cases, thereby increasing the time delay. And this includes trying to interview a subject that now is aware that maybe a search warrant was served on his premises and therefore has no reason to speak to us, and establishing a chain of custody for medical records obtained by search warrant. So there are things that we could overcome, but there are delays associated with those things, and we have a clear and convincing standard of evidence that we need to achieve in order to file your important cases. So this interferes and perhaps denies the ability of the Attorney General's office to seek an ISO to protect the public in an expeditious manner. It is uncertain to me how many cases are being handled by HQIU as criminal investigations. We've requested this information, and you've heard about the challenges with respect to Breeze, and I don't know if that's what's affecting it. But in my estimation, this could be as few as 60 cases to as many as 200. I don't know. One solution to this quandary is fairly simple. We have to assign a second investigator to investigate the administrative investigation. Now, you've heard about the priorities that you have as the medical board under statute. Those priorities do not speak of your ability to file criminal cases. They truly only discuss disciplinary. And I know that DCA's mission and goals is criminal. That is part of their priority. So I think that a conversation should probably occur between the medical board and HQIU to make sure that those priorities truly match and what to do when they're not truly matched. And I'm only discussing the parallel investigations where criminal and civil issues come up on the same subject. In order to ensure compliance with the legislature's mandate to use the vertical prosecution regime to achieve public protection more expeditiously, the solution would be, and especially in light of the staffing issues, to permit the Attorney General's office to provide limited investigative services to the medical board to address this issue in the interim while a parallel proceedings policy is put into place and while you have that conversation and while all these issues are resolved between those two parties. This would permit the completion of civil investigations on a timely basis, and we would be able to provide some of that assistance from the Attorney General's office. The funds that would otherwise be used by the medical board to pay for the salaries of currently vacant investigator positions could be used for this purpose, but it's even more simpler than that. Traditionally, on average, our health quality enforcement section leaves unexpended about $1 million on average per fiscal year of its legal funds that you encumber for the use of our attorneys to prosecute your cases. This would be captured under a billing rate. And that could be another solution in the interim to bridge the gap between the priorities at play here, which are all important, the criminal and the civil, but which, for public safety's sake, would be prudent to achieve on a fairly consistent basis, to avoid handoffs of any cases that are old and where the public has not been on notice because we've been waiting for a criminal investigation to move forward. And this type of solution would be available on ISO matters, which are very important to this board, as we've heard in the last board meetings. And it would comply with the statute that the Attorney General directs civil investigations of disciplinary actions. It would help the board comply with its ethical obligations in criminal proceedings. And it would resolve, obviously, the most important issue, which brings us here every 3 months, which is to protect the public and patients from visiting physicians that we know to be dangerous. And that concludes my report.
Thank you.
Thank you.
I'll defer to Dr. Krause first.
Thank you very much.
Thanks.
I'm interested to know from the Attorney General's point of view how our expert panel system is. Is it adequate? Is it broad enough? What do you see as the strengths and weaknesses or any improvements that may need to be made?
That's an excellent question, Dr. Krause. There's a continuing and debilitating effect, I think, by the expert reviewer program. I think the staff here tries their best. I think we have some great physicians out there that want to do the pro bono work, but we still have limitations. And that issue cannot be overstated as having a direct impact on our ability to do what we can to protect the public. Training is part of it. I think a lot of you could do a lot of good in going out there and telling people the importance of your role as a physician to elevate the quality of the profession at large. And also not just to elevate the profession, but to also, it works two ways, Dr. Krause. It works in the way that we file meritorious cases, but don't forget, we also don't file unmeritorious cases. And ultimately, yes, our success rises and falls on the words of our experts. And it is for this reason that the quality and soundness of expert opinions submitted to the Health Quality Enforcement section in quality of care cases is just so very, very important. And the fair prosecution of the cases and the filing of only the most meritorious are of the utmost importance to the Attorney General.
Follow-up is, in your view, is there a adequate ongoing dialogue between the medical board staff and the AG's office regarding where the holes and weaknesses are so that we can work on improving that?
I'll let you answer it. The conversations that happen.
Well, the principal interaction between the medical board, it's more between HQIU and the medical consultants in the field in the selection of physicians as experts. That's where the rubber meets the road, so to speak. There's a limited pool from which to draw. And the actors in that interchange really don't have the ability, as I see it, to try to expand the pool of experts. I think that is something that has to be at a higher level, and I think what Ms. Castro was suggesting is perhaps the board could use its voice and authority to raise the call to members of the profession to step forward and to engage in this peer review process more.
Thank you. I know that the medical board is continuing to work on that on a daily basis. But I'm wondering if there's a mechanism when the AG's office reviews a case and sees that a case cannot go forward because the expert opinion is not strong or not appropriate, or there are differing expert opinions, or there's no availability of a qualified expert. If that specific information comes back to the board in some way, that it can be tabulated so that we know specifically where the greatest weaknesses are.
There is a mechanism, there is a report that we attempt to file each of the DAGs on a case have access to this form, which is forwarded to the medical board to grade the expert in a particular case. You're sort of mixing a couple of issues in your question. If you have a case, it goes out to a couple experts and they disagree on what's what, that means we're not going to prosecute that case. But what it means is there isn't sufficient evidence to show a violation, so we have to conclude that there wasn't unprofessional conduct, and that professional gets to move on and hopefully continue practicing using best practices. So that's not a defect of the system. That's actually what it's supposed to be doing. It's when we do have two experts that do agree and we file a case and then we go to hearing, that's where we sometimes run into difficulties. The defense counsel will spend more money and get an expert with a thicker CV, and issues in the hearing come down to credibility between what our experts are saying and what the defense experts say. So if we can increase the credibility of our experts, that will have a beneficial effect on achieving discipline through the administrative hearing process.
And we spend a lot of time on this topic, Dr. Kraus, because I think that the deputies that handle these cases are definitely expected to treat the experts assigned to their cases with the utmost care so that they return and have a good experience. And I'm going to say that, yeah, if we go to hearing, there is a battle of the experts, and sometimes even great experts that do a fantastic job beg off the next time because it is a very adversarial process. However, I will submit that if it's an adversarial process and the right decision is the outcome, truly the community standard of care was argued between experts in a forum, which is this, that ultimately does the right decision every time, or at least what feels like the right decision under the circumstances.
I would defer to Ms. Kirchmeier first.
Dr. Yip, I'd just like to actually address some of Dr. Krause's questions as well from the medical board side. In regards to us finding out if there are holes in our expert pool, that's something that we have one's vacant, but two AGPAs, which is an Associate Governmental Program Analyst, that are in Southern California that really are the two individuals that run this program working with Ms. Delp. And so those individuals are always on the lookout for areas, and it comes from, I believe, both the Attorney General's office letting us know where they see holes, as well as from Health Quality Investigative Unit that lets us know we're really lacking in this area. And then in the full board packet, I believe it's under 6B, the Enforcement Program Summary, that report there identifies where we have need of individuals. We also use that information to put in newsletter articles where specifically what fields we're missing those individuals in, so we can get that information out to them, to the licensees, so they can assist where necessary. So we do have that interaction, as well as the Attorney General's office, as well as HQIU, do evaluations on the experts, provide those to the board, and then that goes into our database. In regards to recruitment, part of the reason we actually got another AGPA when that position is filled again is to do recruitment, and that is our plan after we get our training. We think the training, because we haven't done training since the end of 2013, we think training is the most important aspect of that right now, which is why we're planning the March one. But we will be doing recruitment, and those individuals are going to be prepared to be able to go out to hospitals during ground rounds, or different things that are happening out in the hospitals, where they can go and make a presentation and try to recruit those individuals. And lastly, but not leastly, one of the board members has actually talked to us about maybe reaching out to the UCs to try to get experts, because that would be a good pool. Those individuals are really busy, but that is a good pool where we could pull experts from as well. So I just wanted to address that.
So I just have a couple of questions. My concern is that it seems that every meeting we hear about staffing issues that are causing holes in the time frame, that investigators being in the wrong place with the wrong entity causing time delays. And my concern is that now that we don't have control over those investigators anymore, that it's no longer a two-person VE program, it's almost like a three-person, three-legged stool. And what I'm hearing is maybe we should go to a four-legged stool. So the more legs we're putting on the stool, we're not getting a situation where we're going to have better outcomes. We're having a situation where we're going to have less outcomes. So I'm not so sure that on a go-forward basis that there isn't some other kind of model that the AG's office should be helping us with. And that might be cross-training. That might be within different departments working on the same materials. But I'm going to tell you honestly, you're not Mr. Gomez anymore, but trust me, Mr. Gomez has heard from me before. And the frustration is that I understand that more cases are coming forward, that more people are doing things that need to be investigated, that less people are working in the state, making less money, having not enough time to do the job. But there has to be a way to make the system work. And if you guys are not going to be able to handle the investigators to do the work, and then we're going to have another group, it's starting to feel like to me that it's the same old record. Now, you guys are lucky because you have new board members who have not heard my comments before. And you've got new people, not so new in the audience, that have heard my stories before. But after a while, the buck's got to stop with us. And the timelines and the time frames and the cases and the expert witnesses that don't agree and the people that don't show up to do testimony, it's an excuse. So instead of figuring out what excuse can we tell this week or this quarter, how about if we try and sit down and figure out how to make the system work?
Yeah. And if I could respond to that, actually,
Sure.
We've had a meeting with the AG's office and the department and HQIU and the medical board to address these very issues.
Mm-hmm.
And the issue of the administrative and the criminal investigations. We did do some research on how many criminal cases are out there. It's less than 100. I believe it's around 75. We don't have that exact data, but we will get that for you. And, I've even had ongoing discussions with the Attorney General's office that we're going to be meeting in the future. And part of this discussion that we had less than a month ago was to develop guidelines on how to make this happen now, currently, with the investigators that we do have. And in that meeting, I think it was a very positive meeting, and the suggestion was by the Attorney General's office and us was to work together jointly to develop these guidelines, and we do have a draft and are going to be meeting to correct this problem and ensure that the public is protected.
I look forward to seeing this happen because it's frustrating. It's frustrating then when medical board members are reading cases because it was a criminal case that took place 5 and 8 and 10 years ago, and the doctor's still not being disciplined or is now being disciplined so much later, and they've been practicing all along, and now we're looking to put retroactively for what's being, it's just the system is not functioning. So somehow it's got to be that either you have more teeth or you have more teeth. I've got an awful lot of teeth. I'm getting, it's frustrating.
And it is frustrating, and I think we're making progress. I mean, it seemed to be a little bit one-sided, but it is not. We are working together to try and resolve the problem.
So make sure that when you come before us in the future that you're giving us this information so that we hear it and the public hears it, and it's not that it's happening between your meetings in some off-site location because you guys are working together. We need to hear more about what's making the train run on time, okay?
Yes, thank you.
Yes, thank you. And I want to just echo what I heard from our medical board, from Ms. Kirchmeier, as a former reviewer. I will tell you it is extraordinarily important to have the appropriate education and training. It is not easy to apply the law when you're not a lawyer. And it's equally hard is when you don't understand it's not just about how you practice, but not to compare one's own practice. I think that the training that's going to be required needs to be put forth between all the agencies, because every case I know that I did, it does take time, expertise, and knowledge that has to be shared amongst all of you. Otherwise, I think it's very hard to take a doctor. He or she may have great technical knowledge, but he or she needs to be able to make that next leap of understanding the Medical Practice Act, our laws, etc.
Okay, great. Thank you. Any public comments from the audience?
Go ahead.
And from those on the phones?
I just
Please.
wanted to clarify for the expert training that we do have all representatives from all sides, both health quality, the AG's office, we have a retired administrative law judge, we have a medical consultant that participates in the training. So the training that's put on really is coming from all the different aspects. And then they talk about the mock cases and actually get to vote during the training with little clickers as far as what standard of care issues are. And then the audience gets to see how everybody voted in, whether the group felt something was within or with not the standard of care.
And I appreciate that, and I guess the point is now you're doing that, and that's great to know that that was happening upstream, but how does that get translated down to the box of records that show up into the XYZ doctor's office for his or her review? And that communication, I think, is important.
And Dr. Bolat, I wrote down everything you said, and we will discuss among our management staff what, if anything, I can do when the rubber hits the road, and it is filed. It's no longer some figment in anyone's imagination. It is filed, and it is going to trial. Because definitely experts really always think it's going to settle, and that is usually true. But then the person who doesn't want to go to trial is there. And I can do a lot on our end to make sure that they understand those concepts, because you're absolutely right. You hit it right on the head. It's not what you do in your practice, it's what the community that you're part of practices.
That's right.
And that is one of the major pitfalls. And it is adversarial. And I think our lawyers try very hard to play devil's advocate when we meet with our experts. And sometimes that has an unintended effect that they definitely don't want to go to hearing. But so it's a very delicate balance, but it starts with open communication with the expert and moving forward, because without them, none of our cases would go forward. They're a very critical part of the cases, as is the patients that bring forward the complaints, trusting that we will do something with what happened to them to protect the public at large.
Thank you.
I actually attended the expert witness training 2 years ago. It's actually very good, comprehensive. Any board member welcome to join. But of course, there's always room for improvement. And actually, one of my to-do lists is to go through the syllabus or training before March with our staff, with your input, and see how we can make it better and make it more worthwhile for individuals to attend to. So great, thank you. Any public comments from the audience, from the phones? No.
Do we have any comments on the phone?
No phone comment.
Great, thank you. Thank you.
Thank you.
So moving on, agenda item 8, Ms. Dell will provide a presentation on the probation unit's roles and functions. I spent a day, January 5th, on the in the Sacramento office with the probation unit. We met about for the whole day with each staff member, work on some cases, the real cases, look at the files, and also understand the whole process. Also reviewed most of those disciplinary guidelines, and all I can tell you is that all I can see is the passion and commitment of our staff member that they share with the board member to carry out our mission of the board is to public protection. They drive to many places to make unannounced visits, and they look at every line, they check with every hint they have to make sure the doctors on probation act properly. We also have the queen of body fluid testing. That I learned a lot about body fluid testing, the glitches and how we can improve on the system, the minute amount of alcohol level that your hand sanitizer can change the reading, etc. So, but I really think my day there was worthwhile, and any board member invited to join them, and it's my goal to be there at least once in between the board meeting to get updated, to be involved with them. So, Ms. Dell, please, your presentation.
Okay. Thank you, Dr. Yet. My presentation is full of a lot of information, so I'll do my best to get through it as quickly as possible. And to my right is our Associate Analyst, Virginia Gerard, who handles our biological fluid testing. So if you have any additional follow-up questions, she's here to also assist with that. So my presentation overview is going to highlight the organizational structure of the probation unit, identify the various positions with the unit, explain the roles of the positions, discuss the possible probation terms and conditions that can be imposed, discuss how probation staff monitors compliance with the terms and conditions, and then I'm going to wrap it up with some concepts and some areas where we have focused improvement efforts with the unit. The learning objectives I hope that you can take away from this presentation is bring awareness to how the unit monitors licensees on probation, create an understanding as to what actions are taken by the unit when licensees violate a term or condition of his or her probation, and to acquire an appreciation that to achieve optimal success of the program, it is a continual process, reviewing the way business is conducted constantly and making improvements over time. The probation unit was created in 2008, and to give you a little bit of a historical information on that, on January 1, 2006, the board's enforcement program entered into a new working relationship with the Health Quality Enforcement Section of the Office of the Attorney General, and thus the vertical prosecution model was created pursuant to Senate Bill 231. At the time of this new working relationship, the board's probation unit was staffed by sworn investigators. However, due to ongoing caseload, staffing shortages, and problems with recruiting and retaining sworn investigators, sorry, that was already talked about. Enforcement Program Management decided to transition the sworn investigators to the Office of the Investigative Services and then create a new classification of non-sworn personnel to monitor the probationers, to include the function of identifying those cases which will require further investigation. The development of this new classification was developed to take the existing non-sworn investigator assistants and transition them into the training and development assignment into the inspector series classification. The reorganization and transition took some time, and eventually the board's current probation unit was created in 2008 with the inspector classification series performing the full monitoring activities of the unit. The transitioning of the sworn investigators to the Department of Consumer Affairs Health Quality Investigation Unit in July of 2014 did not change the structure, nor did it impact the daily operations of the probation unit. There are 3 offices within the probation unit. There's Probation North, Probation LA Central, and Probation South located in San Dimas. And within those 3 offices, there are a total of 25 non-sworn staff to include managers, supervisors, inspectors, analysts, and technicians. And just to provide some statistics, during fiscal year 14-15, the probation unit monitored 614 cases, which equates to a caseload of roughly 36 cases per inspector. 89 additional monitoring cases were inactive because the probationer is out of state as of June 30th, 2015. As you know, this number is fluid because as licensees are placed on probation, some licensees complete their probation. Here is an organizational structure of the probation unit with 1 manager, 3 inspector supervisors, 15 inspectors, 2 analysts, and 3 management service technicians, and 1 office support handles the whole probation unit for a statewide program. Since 2008, this has been the board's organizational structure for the probation unit and has not changed. Briefly on some of the functions of the classifications, the manager plans, organizes, and directs the statewide operation of the unit. The inspector 3 supervisors are now handling the PC 23 and interim suspension order restrictions that need to be monitored for a licensee. They prepare cases for citation, fine, and order of abatements. They transmit the cases and prepare the memorandums that go to the Attorney General's office for violation of probation. They conduct quarterly case reviews with each inspector, and they review the performance of the inspector to provide direction and monitoring of the cases. The inspector 1s and 2s are the ones that actually monitor the cases and deal with the licensees, the probationers, on a daily basis. They schedule intake interviews. They meet with the probationers quarterly. They interview the practice monitors, the third-party chaperones, the billing monitors. They approve all educational and training courses. They schedule psychological, psychiatric, medical evaluations. They monitor the missed calls for biological fluid testing. They prepare detailed quarterly reports. They identify noncompliance issues and send letters of noncompliance reports to make recommendations for further disciplinary action. The management service technicians are assigned to monitor the pen cases, the in-state non-practice probationers, and the toll cases where probationers are in the state of California. And the office technician provides clerical support to the program. The associate analyst position, which Ms. Gerard is in that position, is the biological fluid testing analyst. She maintains a caseload of physicians who also are issued public letter of reprimands and monitors the training and restrictions that are entailed with the PLR. She monitors the biological fluid testing program to ensure compliance with the requirements to abstain from the use of drugs or alcohol. She ensures the biological fluid tests are random and observed and analyzes the results from the contracted laboratory. She prepares cases for transmittal to Attorney General's offices when it requires a petition for revocation of the petition for a biological fluid test, and she also processes petitions for early relief, termination, and modification of probation. Statutory authorities. The disciplinary guidelines were created to implement the mandates of the Business and Profession Code Section 2227 and 2229. And of the 5 actions that can be taken pursuant to Penal Code Section 2227, placing a licensee is one of those actions by placing him on probation. Business and Profession Code 2229, when exercising disciplinary authority, this code states public protection shall be given the highest authority and disciplinary action shall be calculated to aid in the rehabilitation of a licensee, restrict the licensee's scope of practice, and order restrictions to be placed upon the licensee's practice. In other words, probation unit is responsible for monitoring physicians who have been subject to disciplinary action by the board and as a result have been placed on probation with ordered terms and conditions that must be met. The ordered terms and conditions are designed to remediate and rehabilitate the physician as well as ensure the public is protected. Moving on to some conditions found in the manual model of disciplinary orders and guidelines. It's important to stress that these guidelines are optional conditions and that deviation is appropriate when the case warrants deviation. There are 23 optional conditions, and the use of the optional conditions within the orders and stipulated agreements depends on the nature and circumstances of the particular case. Deviation from these conditions is appropriate when the case warrants deviation. I'll now explain most of the optional conditions. And first, there was an error in your packet. Condition number 4 is an actual suspension, and the controlled substance conditions are numbers 5 through 9. An actual suspension is when a licensee is suspended from practicing medicine. To monitor this condition, staff visits the probationer's place of employment and or calls the place of employment and attempts to schedule an appointment with the physician. If there is reason to suspect the probationer is practicing medicine, the probation unit may make a referral to the Health Quality Investigation Unit to conduct further investigation to determine if the probationer is practicing. If determined the probationer is practicing, a case is transmitted to Attorney General's office for violation of probation. Depending on the circumstances of the case that place the physician on probation, an immediate suspension order may be pursued if found to be practicing with a suspended license. Controlled substances conditions 5 through 9. Condition 5 and 6, total restriction and surrender of DA permit, they go hand in hand. These conditions prohibit the probationer from ordering, prescribing, dispensing, administering, furnishing, or possessing any controlled substance. Inspectors run cures reports every quarter to see if the probationer is prescribing controlled substances. Inspectors verify with the Federal Drug Enforcement Agency whether the probationer surrendered his or her DA permit, and the inspectors communicate to the DA that the physician is on probation and cannot be issued a new permit without prior written consent by the board. Condition 7, controlled substance partial restriction. This condition limits the types of controlled substances the controlled drugs the probationer can order, prescribe, dispense, administer, furnish, or possess. For example, a probationer may be ordered to only prescribe, dispense, and furnish Schedule 2 and 3 types of controlled drugs. Inspectors again check cures to ensure compliance with this restriction and also contact the DEA and advise them of the restriction. The inspector will submit a request to the DA for the DA to issue a new permit that limits the types of controlled drugs the probationer is permitted to order, prescribe, dispense, etc. Condition 8, controlled substance maintain record logs. This condition requires the probationer to record all controlled substances ordered, prescribed, dispensed, etc. Inspectors reviewed the probationer's recorded logs every quarter at a minimum and compare the logs to a cures report, looking for discrepancies in compliance with this condition. Condition 9, controlled substances abstained from use. This condition requires the probationer to refrain from the personal use or possession of controlled substances. At the intake interview, the probationer is asked to provide a list of medications they are taking and are instructed to notify the inspector within 15 days of receiving any lawfully prescribed medication. The board's biological fluid analyst is provided a copy of this list of medications. If the probationer has a confirmed biological fluid test for any substance, whether or not lawfully prescribed, and has not reported the use to the board, staff immediately contacts the probationer for an explanation as to why he or she tested positive. This is done to rule out any mitigating circumstances before issuing a cease practice order. For example, a probationer could injure him or herself and be legally prescribed a controlled substance and then subsequently be asked to take a biological fluid test. The probationer would not be in violation if he or she still has time to report the drug within the 15-day time frame. So the circumstances must be investigated, and if the evidence warrants a violation of the condition, the board will issue an immediate cease practice order. Biological fluid test conditions 10 and 11. Condition 10, abstain from alcohol use. This condition requires the probationer to refrain from the use of products or beverages that contain alcohol. If the probationer has a confirmed biological fluid test for alcohol, staff swiftly gathers evidence from the testing lab and the lab's medical reviewing officer to support the positive test for alcohol. Once sufficient evidence is gathered, staff immediately requests the issuance of a cease practice order. Condition 11, biological fluid testing. This condition requires the probationer to contract with a board-approved laboratory and requires the probationer to check in daily with the lab to see if he or she must immediately submit to a biological fluid test. Similar to Condition 10, if the probationer has a confirmed biological fluid test for controlled substances or alcohol, staff swiftly gathers the evidence from the lab and the medical reviewing officer to support the positive test. Again, when the evidence is gathered, staff immediately requests the issuance of a cease practice order. At the October board meeting, a public comment was made that at the board's sunset report, 306 drug tests came up dirty by probationers in the 2011-2012 fiscal year, but that probation unit only reported 33 probation violations to the Attorney General's office and 34 petitions to revoke probation were filed. The commenter alluded that the numbers do not compute and stated if the probation unit's process to detect violations of probation is not working, then patients are at risk. Board staff was very concerned with this comment and researched the accuracy of the statement. It is important to communicate that a footnote is referenced in the Sunset report regarding the 306 reported positive drug tests. The footnote states the number of positive tests include those where the licensee had a prescription for the substance. For example, many probationers take Suboxone as part of their treatment to bout opiate dependence, and this drug will show as a positive test result. And many probationers are ordered to abstain from controlled substances, but not alcohol. In these instances, the test will show positive for alcohol, but would not constitute a violation of one's probation. Condition 13 through 18 require the probationer to take courses or participate in programs related to education, prescribing practices, medical record keeping, professionalism, professional boundaries, or clinical training. These conditions require the probationer to complete the courses or programs within specified time frames. To confirm compliance with these conditions, inspectors receive completion certificates from the probationer, and inspectors may also verify with the program that the probationer completed the courses or programs to ensure compliance. Condition 20, psychiatric evaluation. A board-appointed certified psychiatrist conducts the psychiatric evaluation. Inspectors pick the psychiatrist from the pool of experts the board has within its expert reviewer program. They review the CV, they check ABMS for medical specialty, and they check prior discipline and recent complaint history before selecting the psychiatrist. Condition 23, monitoring. This condition requires the probationer to nominate to the board for approval the name of a licensed physician and surgeon that will monitor the probationer's practice or billing methods to ensure the probationer's practices are within the standard of care, or whether the probationer is practicing medicine safely, billing appropriately, or both. The practice monitor conducts monthly chart reviews and submits written quarterly reports. Any concerns are reported immediately to the board and reported to HQIU to conduct further investigation. The monitor once a year conducts a site visit review of the probationer's office practices in addition to reviewing patient charts. The monitor follows a board monitoring plan that outlines the percentage of patient charts that are to be reviewed by the monitor. Inspectors review the practice monitor's written quarterly reports for compliance with this condition. If the probationer fails to obtain or replace a practice monitor within the specified time frame, the inspector is immediately requests the issuance of a cease practice order. Condition 25, third-party chaperone. This condition requires the probationer to have a third-party chaperone physically present during all consultations, examinations, or during treatment of specified patients, and requires the probationer to maintain a log of all patients seen for whom a chaperone is required. The chaperone must be approved by the board and is required to sign and date each patient's medical record at the time the chaperone services are provided. Inspectors review the chaperone logs and call patients to verify that a chaperone was present during the consult, examination, or treatment. If the probationer fails to obtain or replace a chaperone within the specified time frame, the inspector will immediately request the issuance of a cease practice order. Prohibited practice condition 26. This condition forbids the probationer from practicing, performing, or treating a specific medical procedure, surgery, or specific patient population, and requires the probationer to notify patients of the prohibited practice. In addition, the probationer is required to maintain a log of all patients that receive this oral notification. Inspectors review the logs for compliance and rely on practice monitors if ordered or stipulated in the order to confirm compliance with this condition. The practice monitor, when reviewing patient charts, will look to see if the probationer has violated the prohibited practice condition. When violations of these conditions occur, the probation unit sends a transmittal with supporting evidence to establish the alleged violation to the Attorney General's office for a petition to revoke probation. Moving on to the new uniform standards for substance abusing licensees. These standards contain new conditions that must be applied to cases involving substance abusing licensees. For clinical diagnostic evaluation reports, these are conducted by a board-appointed, board-certified physician and surgeon. The evaluator's report shall state whether the petitioner has a substance abuse problem, is a threat to him or herself. They need to recommend treatment or recommendation for rehabilitation to practice medicine safely. Any concerns during evaluation shall be notified to the board within 24 hours of this determination. The probationer shall not return to practice until he or she has at least 30 days of negative biological fluid test or biological fluid test indicating a prohibited substance. Respondent cannot practice until notified by the board or designee he or she is fit to practice medicine. Violation of this condition is a major violation. Notice of employer or supervisor information. Probationer shall provide the board with information regarding all employers and supervisors and shall provide written consent for the board, worksite monitor, and employer supervisor to communicate together regarding the probationer's work status, performance, and monitoring. Failure to provide this required information is considered a minor violation. Biological fluid testing. Immediately, probationers shall submit to testing and daily check-ins to determine if testing is required. Unlike the other guidelines, the probationer shall be subjected to more random testing up to 104 tests during the first year of probation. During second year of probation, remaining throughout the terms of the probation, they shall be subject to submit to test up to 104 times per year. Only when no positive tests in the previous 5 years of probation may testing be reduced to once a month. When a cease practice order is issued for violations of this condition, the respondent must leave the place of work, and the board will be required to notify employers, supervisors, and worksite monitors that probationers cannot practice medicine while the cease practice is in effect. If confirmed, the positive test is evidence of the use of a prohibited substance, probationer has committed a major violation and is subject to consequences set forth for violating a major violation. Again, this monitoring of the substance abusing licensee terms and conditions are performed by the biological fluid analyst. Substance abuse support group meetings. Probationers shall attend support group meetings and lists at least once per week or as ordered by the board. Probationers required to provide the board with contact information regarding the group meetings, and inspectors will be contacting the group facility to confirm probationers have attended the required meeting, and the facility is also required to provide the board with any unexcused absences within 24 hours. A violation of this condition is considered a minor violation, however, can be deemed a major violation if multiple unexcused absences occur. Worksite monitor. Approved by the board and cannot be an employee or supervisee of the probationer. Worksite monitor must at least meet with probationer face-to-face at least once a week, must report concerns to the board within 1 day of occurrence through a verbal notification, and written report must be provided in 48 hours. Inspectors will ensure all elements are in this report and will have regular communication with the monitor about the probationer. Failure to secure the monitor is considered a minor violation. The standards for substance abusing licensees, unlike the manual model of disciplinary guidelines, define what would be considered a major or minor violation of probation. Major violations are failed to undergo clinical diagnostic evaluation, commit multiple minor violations, is found to treat patients while under the influence of a prohibited substance, or engages in danger or alcohol-related act that is a violation of state or federal law, fails to undergo biological fluid tests when ordered, and knowingly defrauds or attempts to defraud a biological fluid test, or fails to comply with any term or condition of his or her probation that impairs public safety. Major violations that can result in a cease practice order. We can increase the frequency of biological fluid testing or refer to the Attorney General's office for further action. Minor violations are fails to submit required documentation in timely manner, has an unexcused absence at a required meeting, fails to contact a worksite monitor as required, fails to comply with any terms or condition of his or her probation that does not impair public safety. Should this occur, a cease practice order could be issued, practice limitations can be placed, supervision can be increased, documentation can be increased, a cite and fine or warning letter can be issued, the probationer can undergo clinical diagnostic evaluation, or the board can take other action as determined. Since my short time with the board as the Chief of Enforcement, I have been reviewing the way business in the probation unit is conducted to include conducting case reviews and review the unit's policies and procedures manual. Some improvements identified within the 6-month period are: we are going to hire a new senior staff position, a staff service manager 2, which will be able to assist the daily operations of the probation unit. They will provide oversight in more case reviews and will be able to develop training for the probationers. They will implement a random quality assurance case reviews that will happen in addition to the quarterly case reviews by the Inspector 3s. We've also restructured the duties performed by analysts to provide oversight of licensees subject to biological fluid testing. We will now have 2 analysts that will be overseeing the biological fluid testing, so Ginger will get some relief with her caseload. Inspector 3s are now responsible for monitoring the PC-23 and the ISO restrictions and conditions imposed. We are reviewing all form letters, templates, and checklists to ensure they are up to date with current policies and procedures. We are improving the way that transmittal packets are written to include the gathering of evidence to support a violation of probation. We have added language to the board's public letter of reprimand to include timeframes for completion of courses, and added language that noncompliance may result in further disciplinary action for unprofessional conduct. And also, we are examining the biological ETS threshold that alerts or demonstrates that someone has significant consumption of alcohol. This concludes my presentation, and I'd like to finish by stating, since the last board meeting in October, the probation unit has submitted in less than 3 months 10 transmittals to the Attorney General's office petitioning to revoke a licensee's probation for noncompliance with ordered terms and conditions. I hope with the enhancements mentioned, the development of new procedures, and the enforcement program's continual assessment of the unit's practices will bring confidence to the board members and the public that the probation unit is effectively monitoring licensees placed on probation. Thank you.
Comment, please.
I do. I was trying to figure out how to get the phone to stop beeping, but I can't figure it out, so I apologize. It sounds to me like you've really hit the ground running, and I want to thank you for all of that information. But what would you say would be an optimal time lapse between a break in the monitoring responses to some sort of next steps? What would be 24 hours? 48 hours, a week, a month?
A break meaning for what violation?
For 1 through 26 in the beginning, for the...
Well...
Or for any, I mean, we're talking about serious breaches of competency.
Right, well, I know, like, the programs, they do have specific timelines. They have the probationaries to enroll within 30 days.
No, I'm
and
talking
complete.
about, let's start with the more egregious kinds of situations, alcohol, substance abuse, infractions.
Those are immediate, so
What does
upon
the term immediate
notification,
mean to me, the consumer?
within 24 to 48 hours, the cease practice is submitted up to executive office for approval, and the packet is submitted to the Attorney General's office to move on a petition to revoke probation.
And what kind of time frame does that take?
24,
48 from you, and then?
To the Attorney General's office?
To the completion, till it's complete.
I'm not quite
How
sure.
long should
Maybe
it take?
Kim has.
So it really depends upon the violation that is brought forward. Just as you said, Ms. Yaroslavsky, if it's a drug or alcohol, and I believe Ms. Delp touched on this too, as soon as we get that positive back, the first thing that happens is Ms. Gerard here gets a call to the individual to find out what the reason was. Then once that happens, depending on the language, whether it's the old language or the new language for the violation, then we start the packet to issue a cease practice that goes out to the physician. Like Ms. Delp said, our plan is between 24 and 48 hours. Once that goes over to the Attorney General's office, if they have the old language, they are put on the spot right then and there because they only have 15 days to actually file an accusation. Mm-hmm. Once that accusation is filed, it's supposed to be heard by an ALJ within 30 days, but what usually happens is both sides will waive that 30-day time limit because they need to prepare for their case. So then it depends on when that case is going to get set for hearing. That's all out of our control, so it could be anywhere from 6 months to a year, depending on how long it takes to get that set for hearing and when the hearing is held. But according to what it states in the disciplinary guidelines, that should be set within 30 days. I don't know. I'm going to look at Gloria to see if we've ever actually had one that has actually gone within 30 days. It's probably very rare. But at the same time, the individual isn't practicing, so he's trying to get it.
So there's no practice, so I want to be clear on this.
Not after a cease practice, and there are certain conditions that have that cease practice language in there. So let's go with one that's maybe not as egregious. So let's say he doesn't have a, give me one, Ginger.
No, I want to be real clear that I heard you correctly, that once a cease practice has been issued within 24 to 48 hours, that person is no longer practicing.
Right. They have 3
End of
days
conversation.
from the time that is issued to them. They can't practice, and then they don't practice until the resolution of that accusation, or it'll be a petition to revoke. They can't practice until that's over. However, if we miss any of those deadlines, then that automatically lifts that. That's why it's so important for the AG's office to get the accusation or the petition to revoke filed and all of that to occur. Now, one thing is if it's a minor violation, let's say they don't send in their quarterly report, we'll send a letter back to them. and usually the monitor will know, have a deadline. That might take a couple weeks for them to hit everybody on their roster to see, okay, did this person send in their quarterly report? If they didn't, then they'll send a letter to the individual or contact them by phone and ask why they haven't complied with their quarterly report. So it really depends on what the violation is.
Right, I can understand that. So, but could the public assume that within a certain period of time, regardless of what the violation is, immediate to something out there 3 months, out there 6 months, out there a year, and should that time out there be pulled back? I'm just suggesting that when it comes to, when push comes to shove, I understand that there are things that happen or get in the way of, but by the same token, that's not the norm. That's the outside the norm. So for a normal process, should the public expect that from 24 hours to what date, what time would be appropriate? I mean, I'm not saying you need to answer us now, but I sure would like to have an answer.
Yeah, and we can look at that and come back with some issues, some answers to that question. The one thing is it's the same that we would see with when we get a complaint. We want to move those as fast as possible. Now, granted, we have an individual who's already been found to have violated the Medical Practice Act, and so we want to act on those as quickly as we
Correct.
can.
So that's number one. Number two, the thing is that when a probationer signs a stipulation agreement as to what will be the terms and conditions of that probation, I know I've asked the question before, and I've probably received a very smart, reasonable answer, and I forgot. But at that point in time, could there be some legal ramifications that they are signing that they understand within the opportunity of having to be issued a stop practice, that if they break the terms and conditions of probation, they assume that this might happen to them? I mean, is there something that we can put of some kind of stronger language so that the person signing, the person that has been the applicant that is found to be in probation, has broken rules and regulations, has signed specifically that they understand that they might be asked to be stop practice? Would that give you?
I know that Virginia, I know at the intake interview, they do sign many documents.
Right, I know, I've read them.
And that's what I was going to say. There's two places where that comes in. First of all, that should be happening with his or her attorney when they're getting ready to sign that. That attorney should be going over all of those terms and conditions and explaining that to them, as well as our deputy explains that to the other respondents' counsel, what these mean. Then when they do that intake interview, they sit down with that order. Our probation monitor literally sits down and walks line by line through each of those terms and conditions that are on that decision and makes sure that that individual knows, if you don't comply with this, it says right here, we're going to issue a USC's practice order. So that's going to happen.
And the person is signed that they understand that?
Do they sign anything?
They do sign
So
it.
they do sign.
Acknowledgement of decision.
Okay, I want to just take it out of the realm of possibility and put it into the realm of reality.
Yeah. It's interesting, our probation monitors have reported back that where the breakdown seems to be, though, a lot of time is in that upfront with their own attorney, that all of a sudden when they sit down with our probation monitors, they're like, I didn't realize it was going to do this when I signed the stipulation, which is too late for that individual because it is now that this matter is effective. But at the same time, we do explain it to them and they do understand it at that point.
One last question. You mentioned you're going to have a new hire.
Yes.
Can I ask you when that's going to take place?
We are conducting interviews on Monday.
And you have candidates?
Yes.
And you're prepared to hire someone from those candidates?
That is my plan, yes.
So we would have a new employee within what framework of time? I know I'm pulling, but I just, I'm hiring, I'm going to hire, we need more employees, I want to...
Well, I can commit to making selecting a candidate within 3 to 5 days, and then I pass it off to the Department of Consumer Affairs, who needs to do the final approval. We can continue.
So can I say by March 1st we'll have a new employee in place? Can I say by October 1st we're going to have a new employee? What's the story here?
It would be March 1st, no later than March 31st.
Okay, thank you.
And again, that is because that individual has to stay at his or her job, depending on if it's a promotion or not, for either 2 weeks or 30 days. So it
I'm
depends
just
on
trying to understand the process that we're going to have a new employee within a reasonable amount of time out of our office in the hands of DCA that are going to return that information and make it happen.
And both our staff and DCA staff have been really timely on our hires, so
I noticed, so I
we
just
should
want to,
have
I
it.
thank them for that, and I thank you for that, but I'm sitting on this side of the table. I want to make sure of that.
Yep.
Thank you.
Yes, I have just a technical question. You were talking about that footnote and saying whether or not the urine test was positive or negative. Who is responsible for running those tests, and how do we determine we use a positive or negative versus a test that'll say, I took NyQuil last night, or I took my Suboxone, or I took my oxycodone?
I'm going to defer to Ginger, who's been doing the biological testing.
Thank you.
Hi, Doctor.
Good afternoon.
I just want to say it's a real pleasure to sit across from my own board, and I am slightly nervous.
We don't know what you're going to say, so there's no wrong answers. Don't worry.
Ma'am, I heard about the teeth. I was here for that.
My dentist is very appreciative of my teeth.
Yes, ma'am. The biological fluid questions, yes, I was upset at the large number that was reported, and actually we gave those numbers to the board, and we put that footnote down there. But your question regarding NyQuil, NyQuil would test positive for alcohol. That would be one violation if a person is not supposed to take alcohol, but dextromethorphan is not usually an issue depending on the substance of abuse for the physician. Did you have another?
Right. Basically, the question is, go ahead.
I can follow up. So what happens is we actually contract with First Lab, and so they do all of our testing. Once that positive comes back, so they have a panel that they run it against, and they look at that. I think ETG is set at 250 milligrams. Is that?
It's at 250, the threshold.
50 is the threshold. So when that comes back as a positive, we're looking at that medical reviewing officer to enlighten us as to could that be an incidental exposure, or is this actually a true positive? And then that's when we start down the process of calling the physician and then going ahead and violating him.
And that is one of the enhancements that we're going to continue to look at, is the threshold that we're talking about for the incidental exposure. We're going to be meeting with some experts to get a firmer understanding what the threshold is, and are looking at moving into procedures that when it hits a certain threshold that we can go in and set a biological fluid testing and request it ourselves at the board level, not rely on the lab, and set it and request a blood test.
I see. So you would set it so you might have a reflex test. But the another specific question is that there are, right, we could run a lab that would say this is Suboxone, this is oxycodone.
Yes. It
So
says specifically.
so you do that
Yes,
type
there's
of testing.
panels.
That's what I thought. So I was unclear about how some of it was not picked up, because I would want to know whether, because if the if the person's on Suboxone, that means they're under treatment.
Yes.
Right? So that makes a big distinction.
And we can tell what the drug is that they've tested positive for.
And actually, naltrexone is probably responsible for about 150 of those positives,
I
because
see.
we have about,
And they're under treatment.
right, so, yes, doctor.
Thank you.
Any other comments? But some of you think the presentation is long and tedious, but that reflects the kind of job they have to do every day. A lot of work. So thank you. So, any comment from the public? Ms. Feldman?
Good afternoon, Dr. Yip and members of the Enforcement Committee. Julie D'Angelo Felmuth from the Center for Public Interest Law, and I'm the former Medical Board Enforcement Monitor. I really appreciate this very detailed review of the probation program, which I consider to be one of the most important functions of this entire board. Here you have a physician who has been afforded full procedural due process and for the most part has agreed to terms and conditions of probation. And that's strike one and strike two in my book. And if they don't follow those terms and conditions of probation for whatever reason, we need to be assured, in the interest of patient safety, that your probation unit is picking up these violations. As you may recall, I was the public commenter who noted that during 2011-12, there were 306 dirty tests, yet only about 30-ish petitions to revoke probation were recommended by the board and filed by the AG's office. And the response apparently is that includes dirty tests that are actual dirties and also positive tests because the physician is taking some lawfully prescribed medication. I would suggest two things. First, it is a probation violation for a doctor not to report to the probation inspector that he or she has been prescribed a medication which might trigger a dirty test. That's a probation violation. And so when you go through the terms and conditions of probation for these folks, that's something you need to focus on with them. Also, including that information in one big lump, even with that footnote, is not really helpful. I would suggest to you that if there's a way to do this, separate out actual dirty tests from positive tests due to lawfully prescribed medication. The final thing I'd like to say is that this function is so important. I'm concerned about the caseload. I'm concerned about hearing that there's approximately 36 cases per inspector. I'm concerned about the fact that that's almost double the caseload for HQIU investigators. And I think maybe you should take another look at this unit, the staffing of the unit, to determine whether you need additional probation inspectors due to the crucial importance of this function. Thank you very much.
Thank you. We share your comment. Any comments from those on the phone?
If I could just add that, I mean, those comments are valid, and I think just wanted to point out we're taking those steps by hiring a manager and another biological fluid analyst, and we are looking at the workload, and we are assessing it through our reviews, and it probably would eventually turn into getting more inspectors after our review.
So within, I apologize, but within that check, and I appreciate Ms. Felmeth's remarks as well, if there's a way of taking a look at outcomes, so if you take a look at today with X number of employees, what the time frame line is, and what you're trying to reduce, is it by 5%, 10%, 3 weeks, a month, a year, if we'd have something more that we could wrap our arms around and understand, it might not be one employee, you might need to hire 3 employees. You know what I'm saying? That there's got to be a validation of what you're doing based on information. So at some point, come back to us maybe. Thank you, Dr.
And that would just so you know, that same concept would also be applied in the complaint unit, not just in probation.
Absolutely.
So, I mean, that's just
I know that staff is always doing that, but
I'm just saying that's management's vision, is that we are going to be providing those statistics and looking at all the programs, not just within probation.
I know, but we're talking about this now. That's why. But thank you.
Yeah, we definitely need more help, but I think the fortunate thing is that really our staff is so committed, and even 35, 40 caseload, they really do a good job. Really. So, any comments from those on the phones?
Do we have any comments on the phone?
No comments from the phones.
Okay, great. So we move to almost the last item, future agenda. Any comments from the board?
I would like to hear information as to outreach opportunities within the medical expert reviewer after your conference, but as well as what we're doing as far as reaching out and how the response has been and what the methodology is. I'm not sure if it's for this one or the other, but I think it's important for us to have a finger on the pulse of that, and if we need some help, we need to participate. And I would be happy to volunteer.
Yeah. We're actually doing the outreach before the meeting, so.
Yes, I know. So proactive, reactive, whatever,
Absolutely, great. Any comments from the audience? Any from the phones?
Do we have any comments on the phone?
No comments.
Okay, well, we'll move to the last item. We need someone to make a motion to join the meeting.
So moved.
Second.
Great, thank you. Thanks, Ms. Delp.
Can we take 5 minutes before the next meeting starts, sir?
I mean, it's up to the next chairman, so not me.
5 minutes ago? 20 minutes ago? So I'm trying to do something because I'm seeing you see who's in the audience.